SwayamPrabha. Digital India. Educated India.
My name is Devojit Kumar Sharma. I will be discussing with you today the topic of prison administration as part of the course on Criminology, Penology and Victimology. So far as prison administration in India is concerned, we have 4 important legislations that govern prison administration, namely the Prison Act of 1894, the Prisoners Act of 1900, the Transfer of Prisoners Act 1950 and the Prisoners Attendance in Court Act 1955. These are the major legislations, and at the central level, these are the central legislation which govern the prison administration in the country. Though prison is a state subject and the states can have their own enactment or the state laws governing respective prisons within their jurisdiction, but the central laws are to a great extent important for the purpose of administering prisons, because this gives an idea and this gives a blueprint for the prisons in the country as a whole for administering the prisoners or matters incidental or related thereto. Meaning thereby, these 4 central enactments are very important for us to understand and appreciate, so that we get an overview or outline about how administration happens so far as prison is concerned. You all may be aware about the fact that prison is a very close kind of a setup. It is an institution unlike any other institution. It's an institution which is very closed and there is not much of outside intervention. People outside prisons or people in the community or people in the society at large may not be well aware about what happens inside the prison. Yet, we have some of the laws which are governing the administration of it, so far as the prisons in India are concerned. And there are different types of prisons that you may be aware about. The central prison, central jail, it is categorized as central jail, district jail, sub jails and so on and so forth. We will be discussing about those classifications also later on, but at the very outset, I deem it appropriate to take you to what is being outlined in these central enactments, so that you could get an overview of what is the very focus where from the prison administration or the prison personnel derives their authority from. Now, before that, if I take you to our previous lectures, you would notice that we talk about corrections, we talk about the principles of criminal justice, we talk about the theories of crime, and we also did talk about sentencing and punishment. And prison is a place where people are sent not only after conviction, but even before conviction also. That means, in the prison we find there are convicts, there are under trials whose trial may be going on in the respective courts. There are also detainees who have been detained under certain preventive detention acts and so on and so forth. So, it's a place where you will find different varieties of inmates. So, the appropriate word would be prisoners or prison inmates, but then to be more specific, they are under trial prisoners, they are convicts, they are detainees in a prison. That also depends and varies from state to state. If they want to house all the prisoners in one place, or they have separate facilities, or they have such kind of different categories of jail to house convicts, under trial prisoners and detainees separately. So, therefore, where all these things have been laid down is the different legislation, and in addition to that, there is also something called jail manual, which may be applicable to a respective state. The states may have their own jail manual, but then there is also the model jail manual at the central level, based on which the states are expected to make their own jail manuals. At many times, the administration inside the prison is also governed by what is being outlined in the jail manual. And when we talk or discuss about corrections, and that too corrections for the prisoners, we also have to take a reference to the different central legislations, because the prison staff or the prison officials are bound by, they are duty bound to abide by what is being laid down in the statutes. So, to what extent they may be able to serve the cause of corrections for the prisoners also depends on not only what they are expected to do or expected to serve for the cause of corrections, but also what they are duty bound under their legislations, under the enactments, so far as their discipline and other aspects are concerned. Prison officials, prison staff, prison personnel are governed by different laws, and they draw their powers, responsibilities and duties have been outlined in these legislations, as well as at times in the jail manual that I have mentioned to you. In addition to this, the Supreme Court and the High Courts also have been laying down different guidelines. They have also pronounced number of important judgments, wherein they have defined the roles and responsibilities of the prison staff and prison officials, so far as prison administration is concerned. Interestingly, when it comes to correctional administration, the prison officials or the prison staff have got a very important role to play, and as I have said, that important role needs to be seen in the light of what they are duty bound under different enactments, different legislation for that purpose. Now, going to the first one, the Prison Act of 1894, one of the, I think the first legislation for the purpose of creating an uniform system of prison management within India was the Prisons Act of 1894. Now, as I have told you, the very purpose and the objective of this law was to create an uniform structure. Prior to that, there might have been kind of certain other code of conduct which perhaps existed, but this was for the first time that the need was felt to have an uniform legislation applicable throughout the whole country. At this juncture, it may be also useful for us to realize the fact that different states may have their own state prisons act, but more or less the states having their prisons act are in consonance with the central enactment, in consonance with the Prisons Act of 1894. From that perspective, perhaps we cannot ignore what is being laid down in the Prisons Act so far as prison administration is concerned. Now, this Prisons Act of 1894 has altogether 12 chapters and 62 sections, and different chapters are named as, the one is preliminary section, second is maintenance and officers of prison, then you have the duties of officers, admission, removal, discharge of prisoners, chapter 5 discipline of prisoners, so on and so forth. That means all important matters relating to prison administration are being outlined, are given in the Prisons Act. And what we are going to look at today is not the entire Prisons Act of 1894, but the important provisions thereto. That means the provisions which are material for us to discuss, to understand how administration happens inside the prison, is something that we are going to take up today for discussion. Now, in the Prisons Act, the very important, the first important thing that you would notice is the definition of prison. What is a prison? That is something very important, because at times we tend to see the term jail and prison as the same, but what is being defined in the Prison Act is the term prison, and it is defined as, I read, prison means any jail or place used permanently or temporarily under the general or special orders of a state government for the detention of prisoners, and includes all lands and building appurtenant thereto, but does not include so on and so forth. That means it is a place or jail. The word jail finds mention in the definition only, used permanently or temporarily under the special orders of the state government. State government has to notify by special orders that this is going to be the prison, this is the prison, for the detention of prisoners. Remarkably, the word being used here is prisoners. They are not making use of the word like convicts under trials or detainees for that purpose. What they are making use of, the very legislative intent was that the states may not have sufficient resources at times to have separate types and varieties of prisons for imprisoning prisoners belonging to convicts group, prisoners belonging to under trial groups, prisoners belonging to detainees group. Therefore, for the sake of brevity and for the sake of convenience, they have made use of the word called prisoners. So, wherever they are prisoners, and if the state government notifies through an order that for the temporary or for permanently these prisoners may be housed, that is called a prison. And it is also the terminology jail finds mention in the definition of prison itself. Now, another very important section which I would like to inform you here is section 3 subclause 5 that talks about remission. The remission is important because you must have heard about the fact life imprisonment. Now, you must have also heard that in case of life imprisonment, imprisonment is for life, but it is through the system of remission that it is at times reduced to 20 years, 14 years and so on and so forth. But what is remission? How do you see remission? Where is the definition? Definition is very much there in the Prisons Act of 1894, and the remission is defined as the rules for the time being in force regulating the award of marks to and the consequent shortening of sentences of prisoners in jail. That means, if a prisoner behaves well in prison during his or her prison term, the prisoner is awarded marks, and based on the marks, the duration of his sentence or her sentence may be reduced, and that is what is precisely called as remission. And remission as a terminology finds mention, is being defined in the Prisons Act of 1894. Now, there have been several amendments, state specific amendments. So far as remission is concerned, you have states like Orissa, Maharashtra and all, they have made certain amendments to this particular provision, of or this particular section relating to remission in the Prisons Act of 1894. Now, another section that you have to take notice of is section 5, which talks about inspector of prisons. Now, the inspector of it is not the inspector of prison, but inspector general of prisons, and the term is an inspector general shall be appointed in territories subject to a state government and shall exercise subject to orders of the state government the general control and superintendence over prison administration. That means, the inspector general is the controlling authority for the purpose of prisons in every state, and that is what is being outlined in the 1894 Act. Now, he or she is the nodal person, the highest authority so far as prisons are concerned. Now, the department at times, what if it is called as Inspectorate General of Prisons. It is like Inspectorate General of Prisons, because there may not be one prison, there could be number of prisons. That is why the terminology of the word is used as prisons. Now, if the IG prisons is the highest authority, below him or her we have the superintendent, and it is being laid down in section 8 that all officials, all officers of the prison, all other prison of personnel shall obey the direction of the superintendent. It is a very disciplined force, like what we have as part of police administration. It is a very disciplined force. So, they have to obey the orders of the superintendent of prison in a particular setup. And there is also a position called jailer, which finds mention in the same section 8, and it is stated that all officers subordinate to the jailer shall perform such duties as may be imposed on them by the jailer with the sanction of the superintendent. That means, other subordinate staff are duty bound to obey the instructions of the jailer, and the jailer is in return, or jailer is bound by, in fact, by the directions and instructions given by the superintendent. That is the structure that you have in the prison. That is why it is not very easy that an outsider going and kind of visiting prison without the appropriate permission from the prison superintendent, or even mostly without any previous permission from the IG prisons. Even for the visitors also, it is required that the permission has to be accorded by IG prisons, and stating the reason and purpose for which the visit is there. And reason being very simple, it is a setup where there could be security lapse, and because of security lapse, because of similar problem, people might even escape from the prison, and there have been innumerable cases where prisoners escape from the jail. Now, in such situations, person who will be held responsible is the superintendent. If there is a security lapse, if someone escapes, if anything goes wrong inside the prison, and let me tell you, it is not very easy to manage a prison. You have varieties of prisoners, who are there, maybe under trial, or maybe the convicts, detainees, having different backgrounds altogether, because of which they are in the jail, they are in the prison. To manage such people itself requires a different state of strategy. That is why it is said that the correction, prison management or prison administration or correctional administration is very different from other types of administration, like civil administration, maybe the military administration, academic administration, because the kind of people that you are dealing with is somewhat different in the background. And that is why it is also important and imperative that you have a setup which is strictly based on discipline, so that there could be no lapse either on the part of prison officials or the prison staff or on the part of the prisoners. Now, as I have told you, there is a kind of discipline which is maintained inside the prison, that is the mandate of the Prisons Act, but in reality what happens, that is for us to see. But it is also being laid down in the act in itself that the jailer shall not leave the jail without permission. That means, jailer shall not be absent from his or her duty even during the night time. The jailer has to be there in the prison throughout the whole day and night. That is what is being laid down. Now, chapter 5 of the Prisons Act deals with discipline of the prisoners. As I have told you, discipline is not only important for the prison officials or the prison staff, discipline is equally important for the prisoners, and that is what is being laid down in the Prisons Act. Now, it deals with different matters, and most importantly the separation of prisoners is something that is being laid down so far as discipline of prisoners is concerned in section 27. Now, it says that female and male prisoners should be separated. It says that in a prison containing female as well as male prisoners, the female shall be imprisoned in separate buildings or separate parts of the same building in such manner as to prevent their seeing, conversing or holding any intercourse with the male prisoners. So, the fact of separating male and female prisoners is something laid down in the 1894 Act in itself. It has also laid down that civil and criminal prisoners should be separated. It also has provided for the fact that prisoners below the age of 21 years should be confined in a manner which is different from the other adult prisoners. And I would like to quote what is being stated here in section 27 subclause 2. In a prison where male prisoners under the age of 21 are confined, means shall be provided for separating them altogether from other prisoners, and for separating those of them who have arrived at the age of puberty from those who have not. Now, all these things are being laid down so far as section 27 is concerned. Now, it also deals with, the Prison Act also deals with the subjects such as association and segregation of prisoners. Now, it depends from subject to the requirements of the particular context, stated that convicted criminals, prisoners may be confined either in association or individually in cells or partly in one way or partly in the other. That means, the very separation of convicts from others is also indirectly being dealt under the provision of 1894 Act. Now, there is also the provision for solitary confinement, but what is being stated is important for us to look at. No cell shall be used for solitary confinement unless it is furnished by the means of enabling prisoner to communicate at any time with an officer of the prison, and every prisoner so confined in a cell for more than 24 hours, whether as a punishment or otherwise, shall be visited at least once a day by the medical officer or medical subordinate. That is something that is being laid down very categorically. Now, in to summarize, we can say that these are the important provisions so far as the Prison Act of 1894 is concerned. I am not dealing with each and every provision of the Act, because that will take a lot of time. What I am trying to do here is that only picking up the important provision, so that you have an overview of what is being outlined in the statutes so far as administration in prison is concerned. The next important central enactment that we may have to look into is the Prisoners Act of 1900. Now, why the Prisoners Act of 1900 is important? Because it has got some of the important provisions dealing with the very aspect of parole. You must have heard about that. In section 331A, the Prisoners Act of 1900 mentions about the constitution of district parole board, which is very important. As you know that probation and parole are some two of the very important correctional techniques and though we have a separate legislation on probation, but then parole is a subject which is being dealt under the Prisoners Act 1900. And what is being stated here is that 31 capital A, that there shall be established for each district a district parole board consisting of district magistrate, superintendent of police, 2 members of state legislature to be nominated by state government, and the superintendent of jail, or if there is a central jail in the district, the superintendent of the jail. That means district parole board is something, a statutory requirement under the Prisoners Act of 1900, and not only that, the constitution or the establishment setting up of parole board is itself will not serve the purpose unless there is sufficient powers being given for the release of such people on parole. Now, this act deals about the aspect of releasing prisoners on parole, and for that it mentions or it contemplates that now on the recommendation of the district parole board, people may be released on parole with some conditions being imposed on them for a period not exceeding 30 days at a time, and provided there are certain conditions, provided that no prisoner shall be released unless he has served for a period of imprisonment not less than 1 year. It should not be less than 1 year. Only the prisoners who have served for more than 1 year is entitled to be released on parole. His conduct in the prison has been satisfactory in the opinion of the jail administration, or rather in the opinion of the district parole board, and there is also no reasonable opportunity or probability that during the period of his release he shall not commit any crime. That means, during the period when he is being released on parole, he would not commit any crime, and if he has already got similar kind of benefit earlier, there has to be a gap of 6 months. That means, only after getting the benefit of parole, only after 6 months of your previous parole benefit one is entitled to be released on parole, and that is again a very temporary release kind of thing for a period not exceeding 30 days at a time. Now, it is also being laid down that the parole is not applicable in cases of those prisoners who have been convicted of an offence specified in the schedule which is annexed here. There are some specific offences, kinds of offences where parole is not given, parole is not granted. Now, also those who are habitual offenders, this benefit is not given because their chances of relapse or their chances of committing further crime is there. That is why it is being laid down in the Prisoners Act that such prisoners should not be released on parole. Now, other than parole also, what is being laid down in the Prisoners Act is the provision of releasing prisoners for special reasons, and this on special reason prisoners can be released, but not for more than 15 days, not exceeding 15 days, either without conditions or upon such conditions specified in the direction as the prisoner accept and may at time cancel his release. Now, it again depends on the state government to have their own criteria and conditions of releasing prisoners temporarily for a period of 15 days or even less than that on case to case basis. Now, the state government has also been empowered under the Prisoners Act of 1900 to make rules for carrying out the purpose of this act. That means, the procedure to be followed in case someone has to be released on parole or someone has to be released on 15 days temporary, they have to be given the benefit of 15 days of temporary release, and then so on and so forth. Now, those specific state specific guidelines and the rules the state government is empowered to make. That is why we find that so far as the benefits such as parole and temporary release are concerned, it varies from state to state. There are state specific rules which may vary from place to place, state to state, and this kind of benefit is given to the state, or the states have been empowered under the act, so that the governments at the state level would be in a better position to make their own judgments depending on the contextual factors. And this also justifies why the prison is a state subject, though we have the central enactments, because the problems of prisoners or the problems of crime and the law and order, I mean it cannot be very uniform in the country as a whole. It is very contextual. There are social and cultural factors related to it. Therefore, only the issues, concerns and problems can be adequately addressed at the state level, rather than having a very uniform structure controlled by the central government. Precisely, that is the reason why these things have been, state governments have been empowered to make their own rules and regulation, and in fact, even after independence, we have retained in the constitution the subject of prison as a state subject under Schedule 7, precisely for the reason what I have just narrated to you, because they are contextual, social, political and cultural factors related to it, crime, law and order, prisons, correction and so on and so forth. After the Prisoners Act, you have the Transfer of Prisoners Act 1950. Again, it deals with, it is a very small act, and it deals with removal of prisoners from one state to another. Again, what is being laid down in this act is, where any person is confined in a prison in a state under sentence of death, or under or in lieu of sentence of imprisonment or transportation, or in default of payment of fine, or so and so. Now, in such cases, the state government have been empowered to remove prisoners from one state to another. That is what is being laid down, or that is what is being empowered by the Transfer of Prisoners Act 1950 to the so far as the state governments are concerned. That is very small, as I have told you, it is a very small brief act, and that is the only thing that is mentioned in the act. Now, another important legislation which is important for us to discuss here is the Prisoners Attendance in Courts Act 1955. What is this law all about? Now, the fact that the prison or the jail authorities cannot refuse anyone who either have been convicted or who either have been, whose trial is going on, that is something that finds mention in this act. Now, power of, and more than that, the courts can also seek help of such prisoners, for the purpose of any other trial which may be going on in a particular court. And if I have to read out this section, that is section 3 of the Prisoners Attendance in Courts Act 1955, it says that any civil or criminal court may, if it thinks that the evidence of any person confined in any prison is material in matter pending before it, it can make an order in the form set forth in the first schedule, directed to the officer in charge of the prison, provided that no civil court shall make an order under the subsection in respect of a person confined in a prison situated outside the state in which the court is held. If there is a court order, the prisoner has to report to the court, and the jail authorities, they have to facilitate that. Now, the jail authorities cannot give an excuse that since such person has been imprisoned by virtue of this case, either as a convict or on a trial, the person cannot go or cannot attend to the court proceeding. It is not like that. It is being laid down that the courts have the power to even the call, even to require the attendance of any person, including that too of a prisoner who has been imprisoned in a prison. Now, as I have mentioned to you at the beginning, that there are different types of jail which are in existence in India. Now, these different types of jail may vary from state to state, but so far as the state specific prison sector concerned, in many states it is being laid down therein. I have just picked up one state specific prison act, that is the Assam Prisons Act 2013, which defined different jails, and I would like to tell you about what the manner in which it has been categorized, the types of jail. One is the central jail. Now, it is being stated in the 2013 Act like central jail means a class of prison meant for centralized detention and correctional treatment of offenders sentenced to relatively long terms of imprisonment. That means, prisoners who are undergoing long term of imprisonment are primarily to be housed or to be kept in a central jail. That is what is being laid down in the Assam Prisons Act of 2013, and also for detention of such other persons or class of prisoners as specified by rules made under this act and orders made under such rules. So, that may again depend upon the state government, or that may vary from state to state, but for the purpose of this act it is being laid down that for those prisoners who are undergoing long term of imprisonment, they are to be housed in the, or they are to be kept in the central jail. Then comes the district jail. What is the district jail? Is a class of prisons meant for detention of all classes of persons committed by the courts of a district or subdivision thereof. Again, the district jail also all classes of person, but they are not mentioning about the fact whether the people are to undergo very long duration of imprisonment or short. They are simply saying all classes of person. That means, there is no much difference between the central jail and the district jail, except the fact that in the central jail persons undergoing long duration of sentence are to be kept, whereas district jail is all about detention of all classes of person committed by courts of a district or subdivision thereof. Now, then comes the very concept of sub jail. What is a sub jail? It is again a term similar to subsidiary jail, means a class of prison meant for detention of under trial persons committed by the courts of a district or subdivision thereof. Now, the very word of under trial prisoners comes here, that the sub jail are primarily meant for the under trial prisoners, but it so happens that practically it may not be possible in almost in many of the central jail as well as district jail. We find that they are not only convicts, but also they are under trial prisoners, because their capacity is very limited. The capacity of the jails may not be in proportion to the number of increasing population, because as the population increases, so is the prison population might also increase. But do you have sufficient space, sufficient place inside the prison, and that is where the problem arises. If there are more number of under trial prisoners, they also have to be given the facilities alongside the convicts. Now, one cannot even compromise with the facilities, because that becomes a human right concern for the prison officials or the prison administration. So, it is not a very easy task. Nevertheless, the prison administration is even duty bound to have the utmost respect for the human rights concerns of the prisoners. After looking at different legislation on the subject of prisons, let me take you to the history of prison reforms, perhaps that has happened in India, or rather I can call it the very series of events related to it, prison reforms in India. The first thing at the very beginning was somewhat, it happened in 1835, when Lord Macaulay, while presenting a note to the Legislative Council in India, for the first time pointed out the very terrible conditions which were prevailing at that point of time in an Indian prison, and he termed it as shocking to humanity. That that goes back to 1835, and he recommended Lord Macaulay recommended in his note to the Legislative Council that a committee may be constituted or appointed to suggest measures to improve the discipline in prison. And consequently, what happened was in 1836, just after 1 year, a prison discipline committee was constituted by Lord William Bantic for the purpose. And this committee submitted a report in 1838, and this report revealed the prevalence of rampant corruption in the subordinate establishment, the laxity of discipline, and the system of employing prisoners on extramural labor on public roads. This was the finding of this committee. Now, it was recommended by this particular committee that central jail to be constituted or constructed, rather the word would be constructed, to fit up to 100 prisoners at a time. In all provinces, IG prisons to be appointed, jails to fit prisoners comfortably. Now, it was based on the committee's recommendation that central jails were established in different parts of the country. The first central jail in India was established in 1846, and that was the central jail in Agra. And next came central jail prison at Bareilly and Allahabad in 1848, Lahore in 1852, Madras in 1857, Bombay, Alipur, Banaras and Fatehgarh in 1864, and Lucknow in 1867. So, the central jails were set up on the recommendation of the Prison Discipline Committee constituted by Lord William Bantic in 1836. Now, the second commission of inquiry to look into prison management and discipline was appointed by Lord Dalhousie. This was the second commission which was kind of constituted sometime in 1864. This committee made some specific recommendation in respect of accommodation of prisoners, diet, clothing, etc. Now, then came the third jail committee of 1877. This committee saw the jail administration and also made certain recommendation. It scrutinized jail management and matters related to prison work. However, the recommendations or the very findings of the committee were not very well accepted, and it was not very productive committee for that purpose. Now, before I forget, it is also important for you to recognize the fact that certain minimum space for prisoners should be provided in each prison. This was a recommendation of the second commission of inquiry, which was constituted in the year 1864. Now, the fourth jail commission was appointed by Lord Dufferin in 1888 to inquire into the prison administration. Now, why this committee is important or the commission is important? Because it suggested for uniform legislation in the country so far as prison management is concerned. And the Prisons Act of 1894 that I have discussed with you today, nothing but the outcome of this commission recommendation. But the important point to be recognized here is that the central prison in places like Agra, Allahabad, Lucknow came up even before the enactment of the Prisons Act, just after the second prison committee recommendation. That is very interesting to see. Even before the country had the Central Prison Act or the Prisons Act of 1894, there are various parts of the country the central prisons were already set up. Now, the next important paradigm shift in prison administration came, where the reformation and rehabilitation of the prisoners was emphasized, was the All India Jail Committee of 1919 to 20. This is one of the landmark, I would call it major landmark in the series of events which shaped the prison administration, or which shaped the very the prison management of the country was the All India Jail Committee of 1919-1920. As I have told you, for the first time in the history of prison administration, this committee recommended or it talked about rehabilitation and reformation of prisoners, and it was identified as one of the objectives of prison administration. Now, it also made other important recommendation about which I am not kind of dealing in detail, I am not going in detail now. Now, when the constitution came, or which came into force in 1950, it retained the Government of India Act 1935 position so far as prisons is concerned, as I have already informed to you, and kept prison as a state subject, including it in state list 2 of in another 7 schedule entry 4. Now, after independence, the country saw some of the very important reforms so far as prisons are concerned, and lot of efforts were being put into for the improvement of prisons. And the first important thing that happened was the Government of India's invitation to UN technical expert called W.C. Reckless, and who visited the country in 1952, 1951 around, and to study prison administration in the country and to suggest ways and means of improving it. W.C. Reckless, an UN expert, visited the country on the invitation of Government of India, and his report on jail administration in India is another landmark document of prison reforms. Now, this committee or the W.C. Reckless recommended for transforming the prisons into centers of reformation and advocated for establishment of new prisons in the country. And W.C. Reckless made some of the very important recommendations, such as establishment of the kind of what is that, an integrated department of correctional administration is to be set up in each state, comprising of prisons, brothels, children institution, probation services, aftercare services. An advisory board for correctional administration be set up at the central government level to help state governments in development of correctional programs, and so on and so forth. Though most of these recommendations are yet to be followed by many of the states and also by the central government, but then this was a paradigm shift altogether so far as the prison reforms were concerned. Now, in the same year 1952, another important thing happened was the 8th conference of the Inspectorate General of Prisons was held after the lapse of 17 years. Now, it was on the recommendation of the 8th conference of the IG prisons and also by W.C. Reckless, the Government of India appointed the All India Jail Manual Committee in 1957 to prepare a model prison manual. The point that I was referring to in my discussion for some time, the model jail manual is something that the states have to follow so far as their own state specific prison manuals are concerned, and this committee was constituted to prepare a model jail manual. Now, this committee was also asked to examine the problems of prison administration and to make suitable suggestions for improvement to be adopted throughout the whole country. Now, the Government of India also constituted the All India Committee on Jail Reforms under the chairmanship of Mr. Justice A.N. Mullah in 1980. And the committee submitted, Mullah committee we commonly call as, it submitted its report in 1983. Now, the Mullah committee of 1983 made altogether 658 recommendations on various issues of prison management, and this was circulated to the states and union territories for implementation. Then came the Committee on Women Prisoners, which was constituted under Justice Krishna Iyer in 1986. Obviously, they made some of the very important recommendations so far as women prisoners are concerned. Now, in pursuance of the directions given by the Honorable Supreme Court in the case of Ramamurthy versus State of Andhra Pradesh, State of Karnataka in the year 1996, the Government of India also constituted All India Model Prison Manual Committee in November 2000 under the chairmanship of Director General B.P. Randi, to prepare a model prison manual for the superintendence and management of prisons in India. Now, not only that, we have this series of committees and commissions which were constituted from time to time for the purpose of prison administration or management. Not only that, we have some of the important legislation, central enactment governing the administration of prisons in the country. We also have series of international influences in relation to or in connection with prison administration in the country. Namely, number one, the UDHR, Universal Declaration of Human Rights 1948. This was a defining movement, I would rather call it, for the treatment of custodial population. Now, after UDHR, another important thing happened at the international level was the UN Standard Minimum Rules for Treatment of Prisoners 1955. The UDHR was further strengthened by the UN Standard Minimum Rules for the treatment of prisoners, and these were approved by the Economic and Social Council of the UN in 1957, of which India is also a signatory. Now, in these rules, what is being laid down, or it's being mandated that prisoners should be encouraged and assisted in cultivating relations with persons of extra institutional agencies conducive to his rehabilitation and best interests after release. That means, how prisoner can be better facilitated for being assimilating outside the prison, so that after release the person would be in a better position to assimilate or to get accustomed with what happens outside or with the normal functioning of the society. It also made some specific recommendations pertaining to treatment of prisoners, such as general rules, rules regarding separation of prisoners, rules for minimum facilities, rules for under trials and social relations, etc. After that, in the year 1975, there was the UN Declaration on Protection from Torture. This declaration is also important because it lays down that there cannot be any torture on custodial population, including the prisoners who are being imprisoned in prison. Now, at the national level, if I have to give you the major things, so far as prison administration is concerned, there is a body called National Crime Records Bureau, which compiles prison statistics, and the latest statistics we have of the year 2022. Now, in addition to that, section 436A was inserted by an amendment in the CRPC that provides for release of an under trial prisoner on bail undergoing detention for a period exceeding up to 1/2 of the maximum period of imprisonment specified for an offence for that purpose or under any law for that purpose. That means, if an under trial prisoner undergoes imprisonment for more than half of the total quantum of imprisonment specified for an offence under law, that person should be released on bail. That is what is being laid down under section 436 capital A, which was an amendment in the CRPC. Moreover, under section 265A to 265L in the CRPC, in the concept of plea bargaining has been introduced, in which enables pre-trial negotiation between a defendant and the prosecution. This is also in a way is a, I think, positive step towards better, I would call it better management of the prisoners or for the betterment of the prisoners. Now, the model prison manual that I have discussed to you before some time, 2016, it has specific chapters on legal aid and under trial prisoners, etc. Now, additionally, today we have something called the National Legal Services Authorities Act, by virtue of which we have a system in place, that is the National Legal Services Authority at the central level. Also, we have the State Legal Services Authority, and which have indeed established legal aid clinics in the jails to provide free legal aid services or assistance to persons in need. and different awareness campaigns are being organized, or it's being held by the district district legal services authority in the jail to generate awareness among the inmates regarding their rights, regarding free legal aid, regarding look adalots, and including their right to bail, etc. This is a very important initiative being taken by the National Legal Service Authority as well as state legal service authorities from district to district. Now, so far as the status of prisoners in India is concerned, we have the prison statistics that I have mentioned to you. And what is the status of prisons, or what is the state of affairs in the prisons today? Now, I'll give you some important data for that purpose. Total number of prisoners at the national level has increased from 1,319 in 2021 to 1,330 in 2022, having increased by 0.8%. This is the statistics for the year 2022. Now, in total, in 1,330 prisons in the country, it consists of 574 sub jails, 428 district jails, 148 central jail, 91 open jail, 42 special jail, 34 women's jail, 10 Bristol schools, and 3 other than above the jails. So, this is the structure which is there so far as the prisons are concerned. Now, Uttar Pradesh has, so far as the prison statistics concerned, has reported the highest number of prisoners in the year 2022, that is 1,21,609 in number in the jails, contributing around 21.2%, followed by the state of Bihar 64,914. And there are only 16 states and union territories having women jails in the country, out of which are with a total capacity of 7,080 in India. And this is briefly what is being laid down in the 2022 prison statistics that I wanted to inform you. And in addition to this, you would also find number of important judgments that you can refer to, so far as the treatment of prisoners, so far as the conditions of prisons are concerned, given by the Supreme Court and High Courts from time to time. Some of these judgments can be like you have the Sunil Batra versus State of Delhi administration, then we have the Charles Sobra's case, we have the Muhammad Ghyasuddin's case versus state, you have the famous Rudul Sir versus state case, Hussain Khatun's case, and so on and so forth. There are a number of judgments, but the discussion today was primarily meant to understand the nitty-gritties of prison administration. That is why I have confined the whole kind of analysis to what is being laid down in the statutes and what is being given by the international standards, and what has been the efforts by the different commissions and committees from time to time, so far as the prison administration is concerned. I hope you would appreciate what is being discussed in the classes, and I am sure you are going to be benefited out of it. Thank you so much.